Good morning, teacher. So today our group 7, Mini Brewer, will present to you the case study about authorship versus ownership. So first, we need to understand the difference between owner and authors. In terms of terminology, owners is the person or entity who has the legal rights to publish, modify, and republish the work is referred to as the owner. Simply, owners are those who directly assign work or make financial investment for the author to perform the work. Copyright holders mean organizations and individuals that hold one, several, or own the economic rights, etc., according to Article 36 Intellectual Property Law. Ownership rights to comprise the right of an owner to possess, use, and dispose of the property of the owner in accordance with law, according to Article 158 Civil Law. On the other hand, authors mean a person who personally creates a part or the whole of a literary, artistic, or scientific work. Basically, an author is the creator of work such as the author of the book, the photographer who took a picture, the artist paints a painting, a musician who records a song, etc.
Okay, let's move to the part 2, assigned rights. About the author. In accordance with the moral rights specified in Article 19 of Intellectual Property Law, including name the work, put real name or pseudonym on the work, publish the work, or allow others to publish the work, protect the integrity of the work, not allowing others to modify, mutilate, or distort the work in any way that is detrimental to the honor and reputation of the author. About the owner, Article 20 Law on the Intellectual Property 2005, including making derivative works, performing works in public, copying works, distributing or importing, communicating the work, renting originals or copies of uh, cinematographic works, computer programs. Next part is categories. Author must be the person who directly created part or own of the work. Owner may not be the person who directly created the work. Copyright owner include the following cases. The copyright owner is the author. If you took a selfie picture of yourself, you are the copyright owner of that picture. Copyright owners are co-authors, joint on authorship. For example, a textbook in which two or more authors contribute separate components that are intended to be combined into a single work. The copyright owner means an organization or individual that assigns tasks to an author or enters into a contract with the author. The copyright owner is the heir. The copyright owner is the person to whom the rights are assigned. The copyright owner is the authority. Below is a case that will help you better visualize the difference between the author and the owner.
He is a newly graduated student from Foreign Trade University. Thanks to his dynamism and excellence, he was quickly accepted to work in the marketing department of a home appliance company with a well-paid salary. He is quite hardworking, so he is often trusted by his manager to assign some important projects. Until one day, the company was about to launch a new product. So the first task the manager asked was to design a banner for this product. The designer will be provided with the necessary information and images of the product by the company to make that banner. He was assigned this task by the manager. Since it was a big product to celebrate a company founding, he spent a lot of time and effort to make it. It not only working at the company, but he also brought it home it to complete. Unfortunately, the manager criticized his banner and decided not to use it for the advertising campaign. Simultaneously, due to the stressful epidemic, the company had to postpone the announcement and promotion of this new product to 1 month later. Although the job is still very favorable, 2 weeks later, he decides to resign because he has found another company with a higher salary. Everything was fine until one day he accidentally saw a banner designed by himself that was cancelled and reused by the old company on the day of the new product launch. At this time, he was extremely angry and decided to meet this old boss to resolve it. The two sides argued fiercely until the company's legal department joined to clarify. Which side do you think is right?
So in this case, the copyright of own documents, design, sketch, musical, or the work created or prepared for the purpose of advertisement, or in fact, used for advertisement in any form whatever during the term of the employment, shall belong to the company, and the employee shall acknowledge this in writing by signing the duplicate copy of the revised standard conditions of service at the ends as indicated. So in this case, the worker A had relinquished his right of ownership of the copyright of the sketch to the first company by express provision contained in his contract of employment. So he has no right to claim the sketch or argue the first company work was wrong. In this case, that sketch is already owned by that company and they have the right to use and publish it. So that's the end of our presentation about the case study between ownership versus authors. Thank you for your listening and I hope to receive your feedback.